Hello and welcome to the Polity This Week series of Drishti IAS. I am Ritu and today's session is about important economic political events which had happened the past week. So we have come up with a few political events which we are going to discuss, and we are also going to discuss at how it is important for your exam point of view. As you already know that this session is designed for GS2. So read carefully and listen carefully. So moving towards the points of discussion part. So first of all, we are going to discuss the topic reservation in India. This topic was widely discussed in the past week. Then we are going to discuss about the anti-defection law. Then we are going to discuss about the power of governor and federalism, appointment of governor, immunities of governor. So we are going to discuss all these topics in today's session. So moving towards the first, which is the reservation in India. So what we have seen that last week the Supreme Court has given a verdict. In that verdict it says that there can be the classification for SC/ST communities, sub-classification of the SC/ST communities, and that has created a lot of political debate among mainstream media, also among the academicians, that there should be the sub-classification of SC/ST or not. So this is a matter of huge debate, and people were waiting that what is the response of the government into this regard, and people had also started discussing that when this term reservation came, what is the history of reservation and what is the significance of reservation. So in order to meet out all those questions, we have come up with the reservation in India, and we are going to discuss that why reservation is needed, what is the significance of reservations, what are the positive, what are the negatives of reservations, and what is the history of reservation. So coming to the reservation chapter. So if in simple terms, if you will understand that what is the reservation system in this country. So reservation system in this country is that by reserving few seats for the people who belongs to marginalized section of the society, and they can be marginalized socially, educationally, culturally, and now economically also. So but the basic idea of reservation has the social backwardness, and when there was a Mandal Commission, then there was a term evolved which is the socially educationally backward. So this was the thing. So in simple terms, if you will understand that reservation in India, facilitating access to seats in the government jobs, educational institution and legislature to certain section of the population. So in India we have a reservation for the seats for three categories. So first we give to the legislature, it means the parliament, state legislative assembly. Then we have for the government jobs, not for the private jobs, here you have to be very careful. And then we have for the educational institution. So this is also the educational institution is basically for the government educational institution, not the private ones, because in India we do not have reservation in private sector. So whatever reservation we are talking about, that's all related to the public sector. So here you should not be confused. And then there is a question comes that why reservation? Why do we need reservation, and why do certain section of the society needs reservation? So because of the historical injustices done to the certain communities. And who are those communities? So they are the SC, ST, OBCs and women transgender community, and because of that they have been given reservation, because they are socially marginalized, because they are educationally marginalized, culturally marginalized. And when it comes to the women, especially the SC, ST, OBC women, they are marginalized on two folds, one being a woman and the second being a backward women. So because of that reservation is needed, and also it is said that reservation is a positive discrimination. It means that if few people are not equal, in order to provide equal opportunity those who are marginalized, so there should be the equal ground for everyone. So in order to provide equal ground for everyone, the reservation is needed, and this is called as an affirmative action towards the social justice. So this is the need of the reservation, and on the basis of that this idea has evolved. Now we'll come to the next one, which is about the what is the historical background of the reservation? So many people have this idea that Dr. B.R. Ambedkar has advocated about reservation in Constituent Assembly. Yes, it is true that Dr. B.R. Ambedkar has advocated about reservation in legislature and at various places for SC/ST communities, for marginalized communities. But before B.R. Ambedkar, we do have Jyotirao Phule, who had advocated about the reservation system. So William Hunter and Jyotirao Phule in 1882 gave the idea of caste-based reservation system in the country. And you have this confusion that why we do have a caste-based system of reservation in the country, because India is a country which is still caste-based and the society is divided on the basis of caste. And on the basis of caste, exclusion happened, the discrimination happened. So because of that, we need a reservation, and this idea of reservation is given on the caste basis. So this idea came. Then we have that 1933, and at that time British PM Ramsay MacDonald presented the idea of communal award, in which the separate electorates have been provided for few communities. Those are the Muslims, Sikhs, Indian Christians, Anglo-Indian, Europeans and Dalits and depressed classes of the society. So after that, Pune Pact happened because Mahatma Gandhi was not agreeing with this communal award, and Mahatma Gandhi believed that this will create divide among the Hindu section of the society. And then there was a negotiation happened with the Dr. B.R. Ambedkar and Mahatma Gandhi. Dr. B.R. Ambedkar though wanted that there should be the separate electorates for the marginalized section, but Mahatma Gandhi didn't want, and there was a Pune Pact, which was the negotiation between Dr. B.R. Ambedkar and Mahatma Gandhi, and they both agreed at a point that there will be no separate electorate, but the seats for the marginalized section would be increased. So this was the Pune Pact, and overall a single Hindu electorate certain reservation will happen. So this is about the Pune Pact. And after that, when country got independence, we have reservation for the SC/ST community in the legislative assemblies and legislatures, parliament. But later we got this reservation for SC/ST communities in educational institution, government jobs. But we do not have this provision for OBC communities. So from where this OBC term erupted, and who has advocated the idea that there should be reservation for the other backward classes? So we have Mandal Commission, and when the Mandal Commission came, they have given this idea about 27% reservation to the other backward classes, and they had roughly calculated that the overall OBCs of these countries are more than 52%. It means that 50% of this population are OBCs. Now we'll come to the another one, which is about the Indira Swahni case. So here we'll discuss about the Indira Swahni case. So in the 1992, the Indira Swahni case happened, and what happened into this case? Supreme Court upheld the 27% quota and for the OBC communities, and there was a ceiling on overall reservation. And what was the ceiling? So there should be the 50%. This cap should not be breached. It means that you can reserve the population, but within the 50%. So, and in this case also, it has been struck down, the government's notification reserving 10% for the economically backward classes. So right now we do have a EWS reservation, but in Indira Swahni case, it has been struck down by the Supreme Court. And there was a concept of creamy layer which has been emerged from this case, and this creamy layer has said that the people from other backward classes will get the reservation, but for the initial appointment, not for the lifetime. So this was the creamy layer concept which has been come from the Indira Swahni case. Now we'll come to the next one. Next one is about the Constitutional 103rd Amendment Act 2019. So we had discussed about that. There was a struck down of EWS reservation in Indira Swahni case, economically backward classes. But due to 103rd Constitutional Amendment Act 2019, the reservation, 10% reservation has been provided to EWS section, which is economically weaker section of the society, and it had amended Article 15 and 16 of the Constitution, which has empowered that there should be the reservation for economically weaker section of the society, those who are not covered under SC, ST, OBCs, and they will be the given reservation on the economic basis, and the cap has been decided the 8 lakhs, and they have been given 10% economic reservation. Earlier the nature of reservation was social, but this time we have economic reservation, and that has also breached the 50% reservation cap, and they are not falling under the 50% reservation cap. In this 50% we have SC, ST and OBCs. Now we'll come to the next one, which is about the constitutional provision governing reservation in India. So you have a question that do Constitution of India talk about reservation? Yes, Constitution of India talks about the reservation. Part 16 deals with the reservation of SC, ST in central and state legislature. Article 15-16 of the Indian Constitution enabled the state and central government to reserve seats in government services and employment for the members of SC, ST. Article 330 and 332 reservation for seats for SC, STs in the Parliament and in the State Legislative Assembly. Article 243D reservation of seats for SC, STs in every panchayat. Article 233T reservation of seats for SC, STs in municipalities. So we have seen that with time the reservation has evolved, and different clauses, different articles of Indian Constitution talks about the reservation and upliftment of the marginalized section of the society. Now we'll come to the about judicial scrutiny of reservation in India, key cases and amendments. So I had already discussed that recently Supreme Court had said that there can be sub-classification of SC, ST communities, and after that there was a quest that do judiciary always talk about the sub-classification, and at what point of time judiciary had discussed the classification, or in simple words overall reservation of this country. So we have this State of Madras versus Champakaran Doraijan 1951 case, and what was the issue in this case? So the issue was the Supreme Court's first major verdict on reservation, and what was the outcome? The court pointed out that while Article 16(4) provided for reservation in employment for backward classes, Article 15 lacked such provision. So this was the outcome. What was the consequences? So consequence was led to the first amendment of the Constitution inserting clause 4 into the Article 15. So this was the outcome and consequence of this particular thing, allowing the state to make special provision for advancement of socially and educationally backward classes. So under State of Madras versus Champaikam Doraijan 1951, there was a provision made that the state should definitely think about the people who are socially and educationally backward, about their upliftment. Now we'll come to the next case. The next case is about Indira Swahni versus Union of India. We already had discussed about this case that 50% ceiling was into this case, and the concept of creamy layer emerged, and we already had discussed that after this there was a consequence of that Parliament enacted 77th Constitutional Amendment Act, which has introduced Article 16(4)(a), and that has allowed reservation for SC, ST communities in promotions also, and they do have still promotions in what you can say, if you are a SC, ST and if you have a got job. So in OBC you have this reservation for the initial appointment. The moment you enter the Group A or Group B services, before the 40 years of the age, you will not get reservation, your kids will not get reservation. But this thing has been not done with the SC, ST population, and they have been given reservation in promotion too, because their basis of reservation is different from the OBCs, because they have been given reservation because they are socially marginalized, and here reservation is more of social thing, not the economic things, and it is not economic upliftment thing. So that's why the SC, ST population got reservation in promotions too. Now we'll have another case which is about the M. Nagaraj versus Union of India 2016, and what was the issue in this case? So issue was constitutional validity of Article 16(4)(a), and what was the outcome? So outcome was upheld the validity of Article 16(4)(a) with the conditions: SC/ST communities must be socially and educationally backward. They must not be adequately represented in public employment. Reservation policy must not affect overall administrative efficiency. So this was the outcome of this case, M. Nagaraj versus Union of India. This is also about the SC/ST community, their social and educational backwardness. Then we have another case which is Jarnail Singh versus Lakshmi Narayan Gupta 2018. And what was the issue in this case? The issue is reservation in promotions and creamy layer concept. So in Indira Swani case, we have seen that the concept of creamy layer has emerged. And what was the outcome? So outcome is that reservation in promotion does not require the state to collect quantifiable data on the backwardness of the SCs and STs. So when it comes to the SCs and ST, it does not mean that state should have a quantifiable data to provide reservation in promotion. So this was the outcome of this case. And the creamy layer exclusion extends to SC/STs, preventing reservation in promotion for those within the creamy layer. So the creamy layer concept was not included for the SC/ST population, but it was included to the OBC population. Now we'll come to the about the anti-defection law, because of the election and so many political parties were discussing about the anti-defection law, because recently we had concluded election and there was so much news in media that this political person is going to leave this party. Then what will happen in that situation? So that's why we have taken this topic. So here that first we will understand that what is defection. So defection is that if any political leader who is a part of legislative assembly or parliament leaves his/her party and joins some other party, or just not leaving any seat. So in that situation there is a defection. So I am going to read for you. Defection in a political context refers to the act of a member of legislative body such as parliament or state assembly abandoning their affiliation with one political party on whose ticket the member was elected to join another political party. So we have a BJP, we have Congress, we have RJD, we have TDP, we have JDU. And suppose that if any person from BJP decided that he or she will leave the party, in that situation there will be a case of defection. And this often involves a shift in loyalty for the personal gains. And why political leaders do so? Because some other political parties had promised that, okay, if you are this position at this party, we are going to give you a bigger position. So because of that, there is a shift in loyalty for the political gains, for the economic gains. So this can be the reason for the shift in political parties. And this also leads to the breaching of trust of the electorate, because people have voted one person on the basis of that political party, and if any person decided that he or she will leave that political party and will join some other, so in that situation there is a breach of trust of the electorates, because electorates had voted on the basis of your previous party. So this is the thing, and that has also capacity to break the stability of the government. So why anti-defection law is needed? Because there should be the prevention of Ayaram and Gayaram politics. So Ayaram Gayaram means that suppose that any person has contested any election in the seat of Congress, and after 2-3 months the person has decided to shift in BJP or TDP or any political party. So what it gives a message? So it gives a message that Ayaram and Gayaram, it means that he quickly joined and he quickly left. So it will prevent such kind of instability in political arena. Then curbing money power, because any political party is calling any political leader, so they were luring with the help of money, so it will curb the money power. Then ensuring cohesion, there should be the political cohesion between political parties in the parliament, also in the state legislative also. Political stability, if we have such kind of the law, it will helpful in maintaining the political stability. And then responsibility and loyalty. So these are the things which enables us to require that there should be a need of anti-defection law, so that political stability, corruption-less society will be maintained. Now we'll come to the another slide which is about the important provisions of the Anti-Defection Law. So it was enacted in 1985 through 52nd Amendment Act of 1985, and it is a part of 10th schedule of the Indian Constitution. And what are the criteria for disqualification? If any person is voluntarily giving up the party membership, or if any person decided that he or she will vote against the party mandate. So this is the two criteria for the disqualification. And independent members, we have a different rule. So disqualified if they join any party after election, or nominated member disqualified if they join any party after 6 months. So there is a difference, there is no time mention and there is a time mention. So this is about the independent member, this is about the nominated member, and this is about the people who have elected on the basis for their political party. Now we come to the another one which is about the exception. So there is exception to this case: merger with another party with 2/3 member of the support. We have seen various instances of this. And presiding officer exemption. So if presiding officer said that you have to follow this direction, so in that case also there can be exemption. Who will be the deciding authority? In Lok Sabha we have the speaker, in Rajya Sabha we have the chairman. Similarly we have in MLC we have the chairman, and in what you can say, in case of MLA we have the speaker of state legislative assembly. Rule making power: presiding officer can make rules. Role of the whip: so whip ensures the party discipline in voting. So you often have seen that this person has been appointed as this party's whip. So this is like that. Now we'll come to the governor part. And here we have taken so many instances from the governor part. So here we'll have a brief idea about the governor. So governor is appointed by the president, and it is also called as a central agent of, what you can say, agent of the central government or central agent in a state. So here first we will know about the eligibility of the governor. Must be a citizen of India, at least 35 years of the age, must not be member of either house of the parliament or any state legislature, must not hold any office of the profit. So these are the eligibility criteria to become a governor. Then appointment and tenure, part 6, appointed by the president under article 153 of the Indian Constitution. One person can be appointed as governor for 2 or more states, and this has been ensured in 7th Constitutional Amendment Act of the Indian Constitution. Then holds the office at the pleasure of the president, maximum 5 years. So we do not have this exact time period, but we can say that it holds the pleasure of the president. So their tenure is maximum 5 years, and if president feels like that this person is not eligible for a year, so he or she can remove that also. Then powers. Article 161, pardoning powers, we have 164, power to appoint the CM and other minister, 176, special address by governor, 200, power to withhold assent, reservation, reserve a bill, legislative assembly. Article 213, power to promulgate ordinances. So these are the powers we have for the governors. Now here we are discussing about the dual capacity nature of the governor. Constitutional head of the state and representative of the union government, and sometimes they are also called as the agent of the union government. Ending tenure before 5 years, dismissal by the president. Dismissal by the governors without a valid reason is not permitted on grounds of acts upheld by the courts of unconstitutional, resignation by the governor. So how a governor can be dismissed? So he can be dismissed by the president if he has done any unconstitutional thing, and third, he can voluntarily resign also. Responsibilities: appoint CM, other minister, advocate general of the state, member of the state, PSC, judges and judges of the high court and districts, act as an ex officio chancellor of the state universities. So these are the responsibilities of the governor. So now we'll come to the next one, which is about the Supreme Court on the issue. So judiciary also has an involvement on the role of governor in the state. So in the recent November 2023, the Supreme Court held that governor did not have the power to thwart the normal course of law making by the state legislation. So we have seen that there is so much controversy happening between state CM, state ministers and governor. In that situation, Supreme Court has given this ruling that governor did not have the power to thwart the normal course of law making by the state legislature. And the phrase as soon as possible in Article 200 means that the governor cannot be at liberty to keep the bill pending indefinitely. So these two rulings were done in 2023 by Supreme Court. In detail, we are going to discuss about the Article 200. If the governor decides to withhold assent, he or she is bound to follow the procedure provided under Article 200. Though the court spelled out the obligation of the governor in law-making process, it stopped short by providing definitive timeline for governor to make the decision. And recently the Kerala government has also meant that such kind of things are also happening in the Kerala. So here we will discuss about the disputed nature of the governors regarding withholding his or her assent regarding any bill. Also, we can see that there are so much of controversy that governor is interfering in the state affairs. So all these about the Supreme Court has given the ruling. Now we'll have another session about Article 200 of the Indian Constitution. So after a bill passed by the state legislature, it is presented to the governor, and the governor has three options. So give assent to the bill, second withhold assent, reserve the bill for the president consideration. And if assent is withheld, the governor may return the bill with a message requesting reconsideration. If the bill is passed again by the legislature and presented to the governor must give assent. Controversy arises from the phrase as soon as possible, which lacks a specific timeline. So Article 200 deals with the governor's assent, and governors has three options: give assent to the bill, withhold assent, reserve the bill for the president consideration. And many times we have seen that governors reserves the bill and withhold the assent, but here the term is given as soon as possible, and that has not given a specific time period, and which had created lots of confusion between the state legislative assembly and the governor. So that needs a specific time period. Now we'll come to the another one, which is about the president's role in state law making. So we had read this provision that government has this authority, that government can reserve any bill for the president consideration. In that situation, what the president will do? So president, which has been written in Article 201 of the Indian Constitution, president can either give or withhold assent to bills reserved by the governor. If assent is withheld, the bill is returned to the state legislature for reconsideration. The state government has 6 months to reconsider, otherwise the bill lapses. If passes again, the bill is sent back to the president, who is not obligated to give assent. So if the same bill which has been reserved by the governor will send to the president, what president will do in that situation? So this provision, so the president can either give or withhold the assent. If assent is withheld, the bill is returned to the state legislative assembly for the reconsideration. State government has 6 months to reconsider, and if it's not sent, it lapses. So this is the thing. Now we'll come to the next one, which is about the immunities provided to governors under Article 361. So from where the origin of governor immunity came? So it is linked with the Latin maxim rex non potest precare, or the king can do no wrong. So on the basis of that, this particular immunities has been provided. During the Constituent Assembly discussion on Article 361, a member of Constituent Assembly has raised this issue, that extent of criminal immunity provided to president and governor. And this has been raised, but despite these kind of criminal immunity has been given to the governor and president. So we here will discuss that what kind of immunity they have got. So they are non-answerable to the court. The president or governor, while exercising his or her power, is non-answerable to the court. It means that they will not answer anything in the court while exercising his or her duties. Then there is also exception in Article 14, which is the right to equality. Then we have protection for criminal proceeding. So no criminal proceeding can be instituted or continued against the president or governor during their term of office. So if any president or governor is there during the term of the office, so there will be no criminal proceeding against that person. Then there will be the no arrest. Also, no arrest or imprisonment process can be issued against the president and governor during their term of office. And protection from civil proceedings. No civil lawsuits can be filed against president and governor during their term of office for any personal acts until 2 months after giving written notice. So these are the immunities which has been provided to the governor and president, and moreover they both have the same kind of the immunity, that they are free from the arrest, they are free from the criminal proceedings, and if anyone wants to raise any kind of issue, they have to give prior 2 months notice. So this is the thing. Now we'll come to the test part. So on the basis of all these discussion, we have designed a test for you. What percentage cap on total reservation was suggested by the Supreme Court in the Indira Swani case? 33%, 40%, 50%, 60%. So you have to answer this into the comment section. Then we have another one. Which schedule of the Indian Constitution contains the Anti-Defection Law? 5th schedule, 7th schedule, 10th schedule, 12th schedule. This is very easy one. You can answer into the comment section. Now we'll have a last question. What is the time frame within which the governor is expected to act on a bill under Article 200? Within 30 days, within 60 days, within 90 days, as soon as possible. So you have to also answer this question into the comment section. And in the comment section, I am giving you a homework that you have to tell the answer of this thing in yes or no, that can a person appointed a governor of 2 states or 2 or more than states, and if it can happen under which article of the Indian Constitution or under which Constitutional Amendment Act. So you have to answer this, because we already had discussed this particular provision in our discussion. So I hope you like this session. If you have any queries related to the session, kindly ask in the comment section. Thank you and have a nice day.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.